Good morning and welcome to Positively Politics, the show where we break down the sometimes complicated and often negative world of politics in a straightforward and academically rooted way. My name is Dr. Merrifield Wilson. I'm a professor of political science here at the University of Indianapolis, as well as the host of this show. And if you haven't caught this show before, Positively Politics is all about asking questions, inciting conversations, bringing in history and data points to give us a greater understanding and context of what I like to call the political minutia all around us, all the headlines, all the clickbait, all the many topics that can, quite frankly, very easily overwhelm, but are also important for us to understand. And that is exactly what we're going to do here again this morning as we talk about an important Supreme Court case. I'm going to say, just go ahead and say it. I think it's going to be the most important Supreme Court case of this season, this session, if you will, before they ultimately leave at the end of June, maybe even early July. And that's talking about Trump v. Barbara. This is the court case in front of the court of last resort. That's your U.S. Supreme Court on birthright citizenship. And we had oral arguments over this case on Wednesday. Unprecedented. The president, who's obviously named in the case because this involves his first executive order, day one of his second administration, right? Sitting there in the audience as you hear the Supreme Court ask both sides their opinions and their understanding of the Constitution, their interpretation of the Constitution as it plays out with regards to the larger issue and question of birthright citizenship. So we're going to delve into this case today, give you a little bit of historical background and context for the things that I think are important for us to understand. This is also going to lean into a little bit of originalism and textualism, if you will, for my judicial philosophy scholars here. And then we'll talk about its current application, both the political reasons the president utilized this as his first executive order, right? He's issued several in over 1 year into the second term, but there's a reason this was first, right? I think that's important to tease out here and to note. And then finally, we'll talk about what the ramifications could be. I will start by saying there's a lot of things we don't know, and namely what the decision will be. We just heard oral arguments. The justices will still deliberate, decide, they'll write up and review those opinions, and eventually they will be shared with us, of course, but there's a lot we don't know, right? I think it's worth asking the questions, even when we don't know the answers, because this will be a landmark case involving immigration, arguably the most important landmark case in over 130 years since U.S. versus Wong Kim Ark, and that's been a case that's been really important in relation to this conversation about Trump v. Barbara. But let's just dive right into it. I'm Dr. Merrifield Wilson. We're talking today about Trump v. Barbara, which is the question of birthright citizenship. So to start in terms of the immediate needs, the reason why this is a court case is because this was the first executive order. This was day one for President Trump and beginning his second administration, where he issued the executive order that barred automatic citizenship. And this is important for babies in two cases here, right? Certainly for those born in the United States whose parents entered the country illegally. But also, second case here, if the parents were here legally, but they were on a visa, whether it was temporary or short term, right? For babies born in the United States in either of those cases, this would prevent them from receiving automatic citizenship. We call it birthright citizenship. And this is really important in terms of changing, right? Really reevaluating our understanding of the 14th Amendment, which expressly provides for this kind of citizenship opportunity, but has its background here. I mean, you're talking about over 150 years ago. We're going to discuss this. Has its background and its perspective looking at slightly different things. So this comes out of a challenge to the president's executive order. And you really saw two different arguments when we're talking about the oral arguments, right? Two different groups at play here. And there are interest groups that both have a very vested interest in the outcome of this decision. On one hand, on behalf of the president, speaking for the conservative perspective here, you have America First, and their argument in favor upholding, and that's what they're going to try to convince the Supreme Court to do, upholding the executive order that would essentially prohibit the automatic transfer of birthright citizenship. And on the other hand, you have the liberal perspective enunciated through the ACLU, which is going to argue that this is, in fact, a constitutional right that the president does not have the authority to eliminate, to prohibit. So that's the general background in terms of this, but let's get into some of the history, because I find this to be very fascinating. And first and foremost, not trying to criticize here, just pointing out, but for the authors of the U.S. Constitution, interestingly enough, they did not include anything about citizenship. So up until 70 years after the Constitution was ratified, as we were a country, a very new young country, there were no passages, there are no sections, there are no articles that detail and outline what it means to be a citizen in our country. And I think that's very interesting when you consider the fact that for most organizations, not even countries, right? Just most organizations, they will have in their charter, in their bylaws, what constitutes membership, right? And you do that in part so you can identify who qualifies, who counts, probably the process and requirements, the attributes, but you also do that so you can identify and separate who doesn't, right? Do you have to be a dues-paying member? Do you have to attend so many meetings? Right? What does that look like? And I think it's interesting to look at the U.S. Constitution and recognize that that's not included. Right? I don't think, and there's a lot of history on this, right, that the Founding Fathers just didn't think about it. They were pretty thoughtful. And that said, you do go essentially 60 years later before you have the 14th Amendment added to the Constitution. I understand there are many amendments. The Bill of Rights was a collection of 10 amendments that were immediately added in order to have the Anti-Federalists ratify the Constitution in the first place. So I'm not even criticizing that it's an amendment added later on, but just the fact that it's very interesting. And there's been a lot of analysis of this over the years. The predominant thought was that we needed more people, that this country was interested in promoting immigration, and that there wasn't really an interest. In fact, it probably would have been counterintuitive at the point to limit who could qualify, who could be, let's say, a member of our club, who could be a citizen of our country. And because of that interest, it didn't feel necessary to define or decide what counted and what didn't. Right? I even think when you look at the lower level, right? So not citizenship, but let's just talk about residency for a second, right? Residency is oftentimes defined not necessarily in your community bylaws, right, or your state constitution, but really we think of residency being outlined in terms of voting rights. And this is where they come into play, because we say, well, to be a resident, you must have lived here for a certain period of time. Right? We'd also recognize you must live within the boundaries, right, or the annexed portions, but within the area that belongs to the city. And that part is really important. So understand that this was not initially a part. The idea of citizenship and what counted, whether it was naturalized or birthright, was not a part of the original Constitution. Now, I'm Dr. Laura Merrifield Wilson, talking today about Trump versus Barbara. We're going to get to who that person is in just a second. But the question, the constitutional challenge of birthright citizenship, automatic birthright citizenship. And I mentioned that this was issued as an executive order during the first day of Trump's second administration. I think that is really important here, and I'm going to talk about that in a bit too, but also talking about some of the history behind this. So understand the 14th Amendment comes in 1868, and yes, it's added to the Constitution. That's first where we see citizenship defined in very broad terms, but it's also important because this is coming after the Civil War. And at a time, of course, which is very important in our country's history, but the Civil War was essentially a response to factions within states, dividing the states. And in addition to that, the Civil War really focuses on the idea of what states have the right to do with regards to slavery. And I think that's important because a lot of you see this 14th Amendment is a response, a direct response to Dred Scott and versus Stanford, which was in 1857. And this matters quite a bit when you consider the fact that the Dred Scott case, oftentimes cited as among the lowest points in the Supreme Court history, is that this is looking at the question of whether or not a slave in a free state would still have rights. Right? Are they a slave? Are they not? And in particular, with the Dred Scott case, it essentially declared that African Americans, regardless of whether or not they were slaves or free, could not be U.S. citizens. And this is why the 14th Amendment and the language within the 14th Amendment are so important, because you're looking at this argument that is added in terms of the issue of the 14th Amendment, right, that is trying to clearly identify and define who has a right to citizenship. And the interpretation of that has been that any child born in the United States on American soil would have that right vis-a-vis the 14th Amendment. Now, that was passed in 1868, right? That was ratified. It is not the end-all be-all, though, right? And when you think of legal precedent, one of the ways that you can actually go through a legal brief, by the way, it's called the Iraq model, right? You focus on the issue. That is the question of birthright citizenship in this case. And then you look at the ruling, looking at previous rulings and decisions that have been made. And in this case, the one that is most cited, that I think is a fascinating case, is also, again, very, very old. This is a long time ago, over 120 years ago. But this is looking at the U.S. versus Wong Kim Ark case. And this is involving a man who was born to Chinese immigrants who were here legally on the basis in which people would have entered the country in the 1870s. He was born in San Francisco, so he himself was born in this country. His parents were immigrants to the country at the time. Right? They worked in a business in San Francisco, eventually left and went back to China. And then he visited them, but was denied entry upon his return to the port of San Francisco. And he claimed birthright citizenship because he was born on American soil. He had simply visited his parents, who were not Americans, but immigrants, but had gone back to China. And this is a really important case because this is the first evaluation. It is seen as the basis for evaluation that's really held the standard in terms of birthright citizenship since 1898 when it was decided. And this was an eight-person Supreme Court because we had a vacancy, but the ruling was fairly one-sided in a 6-2 decision. They sided with Wong Kim Ark and said that the line in the 14th Amendment, right, this is an important line here, subject to the jurisdiction thereof, was applied to mean that all children born in the United States were automatically granted that citizenship. Now, when you apply the U.S. versus Wong Kim Ark case as precedent, and you're looking at the 14th Amendment, which we said, is established exactly 30 years prior, one of the things that we have to consider in terms of this was the intentionality of the authors of the 14th Amendment in terms of who they conveyed citizenship to. Right? And what the ACLU is arguing is a cultural importance for us in the United States. I'm Dr. Laura Merrifield Wilson, as we're talking today about Trump v. Barbara on Positively Politics. I mentioned the 14th Amendment and U.S. versus Wong Kim Ark that came exactly 30 years after that. And the line that the Supreme Court cited in upholding Ark's birthright citizenship by a 6-2 vote. And they said it was the line subject to the jurisdiction thereof, which is a part of the 14th Amendment. And part of the importance here is that birthright citizenship was given to the birthright of the individual who was born. And it's a really interesting concept because we have no control over where we are born, right? That is to certain extents, right? And of course, it's circumstantial. Yeah, but that's under the control of our parents. But interesting here in crafting of the 14th Amendment, there are no legal citizenship elements given to parents. Now, I recognize the modern implication. Do not get me wrong. I understand you can't have a baby in a place and then say, well, the baby can stay here, but y'all got to go. I've had a baby. Like they don't raise themselves. They never raise themselves. They grow much older and they still can't raise themselves. I'm sure my mother says the exact same thing about me, right? But the citizenship was given. It's conferred to the child, not to the parents. There's nothing automatic about that. And in the Ark case, something I thought was kind of interesting here is that the court did provide 3 exceptions for birthright citizenship, really only one that would currently apply, right? So they said for children of diplomats, children of foreign armies on American soil, and children of Native American tribes, they were not automatically given birthright citizenship. Now, children of diplomats, right, in theory, would still apply here because the justification, the explanation that the Supreme Court gave in the decision of Ark was that the children of diplomats would be children of people who had pledged allegiance to a different country. I don't mean just say in the Pledge of Allegiance, of course, but I mean like their allegiance, their affiliation, their identity. And to be very blunt and clear in this case, their citizenship belonged elsewhere. It was not the United States, right? They are diplomats by virtue of that position. You got to be. But the other 2 exceptions that the court carved out in the Ark case back in 1898 really don't apply anymore. That's the children of foreign armies on American soil. We don't have that right now. And then children of Native American troops. And though I think it's a sad reality of interpretation of the 14th Amendment, right, subject to the jurisdiction thereof, really should have applied to everyone, but it was not applied to Native American children and those Native American tribes until they were granted automatic citizenship, and that doesn't come for another 20 plus years later in 1924. Right? But those are the elements that we see that are the basis, the underpinning for this argument in Trump v. Barbara. It's playing out right now in the U.S. Supreme Court. Now, you're listening here to Positively Politics. I'm Dr. Laura Merrifield Wilson, talking today about birthright citizenship. And I mentioned Trump v. Barbara because we had the oral arguments earlier this week. Now, let's just quickly talk about who is Barbara. I have to say, when I heard about the case initially, I knew the court was going to take this on. This was one of the things I was probably, quite frankly, most excited and interested in, right? It was like, who are the plaintiffs here? What's going on here? And Barbara is not an actual name, right? This is a pseudonym for an individual, but it's a woman that is being supported and by the ACLU, who filed the case and is arguing the case on her behalf. But she is an Honduran immigrant. Now, important to know, she's lived in the United States for 2 years and she has a pending asylum application, but she is not an American citizen. And she has not been granted a visa in that regard. And I think this is important, right? She lives in New Hampshire. She has 4 children. 3 of her children were born before the executive order. So though there are questions, would this retroactively apply, at least for right now? Right? We will stand under the assumption that it won't. But her 4th child, Barbara's 4th child, was born after the executive order was issued back then in October. And when her child was born, in theory, this could absolutely apply. Right? And so Barbara is the pseudonym for this woman. But we recognize, of course, Barbara is not the only woman involved. There's actually 2 other plaintiffs in this case. There's Susan, who's a Taiwanese woman from Utah, right? And then there's Mark, who lives in Florida and is from Brazil. In both of those cases, there are people who have applied or have received a green card but are on a visa. And one of the things I want to remind you that's important in the executive order was it was not just applying to babies whose parents were here illegally, but it also applies to babies whose parents were here legally but on a temporary or a long-term visa. So it's a broad application in terms of who the executive order would apply to. And that's what we're looking at in the Supreme Court case. Now, I mentioned the arguments being placed. We got to hear these in the oral arguments on Wednesday, but America First and the Trump administration essentially are arguing that you could only be a natural-born citizen in the United States on the basis of your parents' allegiance. And they make a connection to criminal activity and then a violation of allegiance to a country, because they note, this was a chief part of the conversation on Wednesday when the arguments back and forth with the justices, that crossing the border, entering the country illegally is considered a misdemeanor in our country. It's a federal misdemeanor. And while it's not a felony, that is still a crime. It is against the law. And the argument that you see America First making here is that if you are violating our laws, how could you claim to have allegiance? Right? I think of the language we recite in the Pledge of Allegiance, right? You say that every day at the beginning of school when you're in elementary school. And it's reciting your commitment, your guarantee, your promise to say, I'll abide by the laws. Now, recognize that a lot of people don't do that, right? Yes, sure, criminals probably said the Pledge of Allegiance. What? And then they committed a crime. How dare they? It's hypocrisy. But, I see this argument, and that's really what America First and the Trump administration is focusing on, is that to be considered an American citizen is a baby. Like, your parents have to have pledged allegiance to the country. And if you're committing a misdemeanor by entering the country illegally, then that's strong evidence, right, that America First is saying you don't meet the traditional notion of allegiance. I'm going to add to this, too, that they signed on to a brief. There were 12 senators and 16 House members, all Republican, if that's important or you weren't sure, that signed on to a brief reaffirming this. But most notably of those, I thought, was Ted Cruz. Now, Ted Cruz is a Republican senator from Texas. He has long been interested in running. He's ran for president unsuccessfully, of course. He was at CPAC in Dallas this past weekend. And Cruz makes this argument that the current policy we have, he says, is stupid because it incentivizes illegal immigration. And what he's pointing to is the concept, this politicized term here, but forgive me if you will, of anchor babies, right? Of birth tourism. And this is documented. We know that this happens. The estimates from the best research I could find, and it was very fuzzy, are 1% of cases, right? But for women who come to the United States with the expressed intent of having a baby on our soil so that they can be American citizens, their child can be American citizens, and then they can initiate the process of themselves becoming American citizens if they so choose, or leaving, but that child always has a connection and a citizenship tie to our country. And that's really what Cruz is alluding to here. Right? Now, on an individual level, I spoke to two people, right? One was a friend, one is a student from different countries who said, oh, yes, they knew of people who did that, right? Like, they actually knew people. Because I think on one hand, sometimes it feels like an urban legend. Same with some of the voter fraud, for example, right? We basically, I don't want to say dismiss it, but we acknowledge that it exists. And we also want to recognize, without getting too much into all of the potential conspiracies, it's very small, right? Not to say that it is good or acceptable or anything like that, but I was, quite frankly, it was opening to my eyes. I was fascinated to hear individuals who said, oh, yes, they absolutely knew people who did this. Now, the other argument was promoted by the ACLU, and they're arguing on behalf of Barbara against this executive order for birthright citizenship to be essentially banned, because the ACLU pointed out that the 14th Amendment was authored with the deliberate intent to allow citizenship to be automatic to the child, but not to the parent, right? They could have easily said that. If you're on American soil and you give birth, if you gave birth here, you get it. No. And I will say, giving birth is the really hard part. I've done it before. It's called labor for a reason. It's really, really hard, right? But no. You do not get that, right? Who gets that, right? That automatic birthright citizenship we're talking about to the child, not to either the mother or the father. And as a sidebar, that was one question that I didn't feel like was adequately addressed in the Q&A, right? In the oral arguments on Wednesday was what happens to the parents, right? What if one parent is an American citizen, but the other parent is not? There were a lot of questions like that we saw come up in those oral arguments. And you're listening here. I'm Dr. Laura Merrifield Wilson on Positively Politics. And we're talking today about birthright citizenship, about the issue in front of the Supreme Court in terms of Trump v. Barber. And I want to quickly talk about why I think this matters and also what we think might happen, right? But this matters a lot to Donald Trump because immigration was a central issue to his campaign, right? And you can control, I think you can control immigration and perceptions of immigration a little bit easier than the economy. Let's compare and contrast, shall we? We have been at war with Iran for a month now, and I realize it's a conflict. We're not officially at war. That would require Congress. And of course, this is the president's action, right? But we've seen gas prices increase significantly. And voters look at that. Voters don't understand all the nuances behind oil production, right? Voters don't understand all the details between who did what, who said what, who's involved in what, right? But voters do understand when things cost more. They will absolutely understand, and they will interpret that, and they will see that, and that will be important to them. We talk about this as sociotropic economic voting, right? Are you better off now than you were 4 years ago? And that's the large scale. We could say, are you paying more at the pump 4 weeks ago now, or what you were 4 weeks ago? Obviously more. And so I'm going to say that immigration as a narrative provides Trump a little bit more latitude. It's a little bit easier to control. And that's why this is an important issue for him. Right? This is something that he wants to be able to point to as a success, as a victory. And it was one of the two big deciding factors in the presidential election of 2024. Now, looking ahead, because we got to, right? We are in an election cycle, but what's going to come of this decision? Well, when we have oral arguments, after that, the justices get to debate and deliberate. If you didn't know, it's really kind of cool, actually. They will discuss the case in order of Chief Justice first and then seniority. So how long you've served on the court. And it goes all the way down then from John Roberts through to Ketanji Brown Jackson. But then when they vote, the Supreme Court will go from newest, right, person who served on the court the least up through the person who served on the court the most, and then that final vote. Sometimes the tie-breaking vote is cast by the Chief Justice, right? And that gives a lot of power in terms of seniority. That also gives a lot of power to the Chief Justice. And I think that process itself is important. But this is a case that we could see come out towards the end of June, which tends to be when the really big cases are decided. I'm thinking of Burgeville versus Hodges in 2015. I'm thinking of Dobbs versus Jackson back in 2022, right? A lot of times these big cases come out at the end of the cycle. And this was relatively late to have oral arguments, by the way, on a really important case. But we're looking at likely June, end of June. And it's unclear what to expect. I'll remind you, we have a 6-3 conservative court. So you might say, well, seems like the ball would be in Trump's favor. And 3 of those justices, Gorsuch, Kavanaugh, and Coney Barrett, were all Trump appointees from his first term, right? But they are lifetime appointments. So you don't necessarily assume that it's just going to go that way. I think Coney Barrett will be one to watch. I think John Roberts always is one to watch. And we would expect that decision probably comes out in June after a majority of the primaries, including our very own Indiana May 5th primary, is complete. But of course, several months before the general election. And what will be interesting to see is how dominant this conversation is, how much this reframes or reintroduces the issue of immigration to the American public. And then, of course, how it impacts the election, because we know decisions on policy, even when they're made by a non-elected body like the judiciary, are incredibly influential in how Americans think and feel about politics, and their sole direct expression of those feelings comes through elections and voting. Thanks for listening to Positively Politics. If you enjoyed this episode, please subscribe and leave me a review. It helps others find the show. I'm back every Saturday with new episodes. You can listen anytime wherever you get your podcast.